Here begins the videotaped deposition of Noreen Considine, Tape 1, Volume 1. In the matter of Jurupa Unified School District versus Noreen Considine in the Superior Court of the State of California, County of Riverside, case number RIC 520530. Today's date is Monday, August 9th, 2010, and the time on the video monitor is 12:49 p.m. Today's date is Monday, The video operator today is Dan Asahi, representing Network Deposition Services, located at 1900 Avenue of the Stars, Suite 2850 in Los Angeles, California. Phone number 800-788-2021. The court reporter is Gina George. Today's deposition is being taken on behalf of the plaintiff and is taking place at 3750 University Avenue, Suite 400, Riverside, California, 92501. Counsel, please introduce yourselves and state whom you represent.
Good afternoon. Stephen Barrett, representing Ms. Considine, the defendant.
And my name is Jack Clark, Clark spelled C-L-A-R-K-E, and I'm an attorney representing Jurupa Unified School District. With me today is my colleague, Megan Moore, an attorney with my office.
Would the court reporter please swear in the witness?
Excuse me, please raise your right hand.
You stand?
No, you're fine. You do solemnly swear the testimony you're about to give in the matter no pending should be the truth, the whole truth, and nothing but the truth.
So help me God.
Thank you.
Ms. Considine, you're here for your deposition. Do you understand that?
Yes, I'm, just a point, my name is pronounced Considine.
Considine, excuse me.
Sorry.
Let me explain the process to you. First of all, have you ever had your deposition taken before?
Yes, I have.
On how many occasions?
I really can't say.
More than one?
More than one, maybe less than 10.
So you understand that the oath you've taken means that you're testifying under penalty of perjury, is that understood?
Yes, it is.
And is there any reason why your deposition should not go forward today that you know of?
No, not that I know of.
Have you taken any medications or had not enough sleep so that you would not be able to give your best testimony today?
No.
Okay. Very well. First of all, would you please state your full name and spell it?
Noreen Considine. The first name is capital N-O-R-E-E-N. The family name is Considine, capital C-O-N-S-I-D-I-N-E.
First of all, you're currently a trustee on the Jurupa Unified School District School Board, is that correct?
Yes, it is.
How long have you had that position?
Since the first Monday in December 2004, when I was sworn in.
In 2004?
I'm sorry, 2008.
Aside from serving as a trustee on the Jurupa Unified School District, do you hold any other positions?
You mean, am I employed?
Yeah, well, employment is fine.
Not currently, no.
When was your last place of employment?
I was self-employed for several years, and I was in the United States Navy active and reserve until June 2004.
And you say you were self-employed during what period of time, ma'am?
I think it was the late 90s and the early 2000s. I can't pin it down any better than that.
Well, what was the type of self-employment you were in?
Industrial hygiene, occupational health, occupational safety. I did expert witness testimony, and I collected samples for analysis, for chemical analysis.
And what is industrial hygiene?
It's the It is let me see how I can say this. After all these years, I was in the business for over 30 years, and my family still said, what is it again that you do? It's to be sure that people who are working in a given location are not being overexposed to contaminants or toxic agents.
And what was the company name you worked under?
I called myself, well, first I called myself something else. I can't remember what it was, Industrial Hygiene Services. And then I just worked under my own name, Noreen Considine, CIH.
And you said you served in the reserves in the Navy, is that right?
I served active and reserve. I was recalled to active duty approximately 8 times in my career.
When were you active in the Navy?
I was active from 1975 to 1978.
And during what time were you in the reserves, ma'am?
From 1978 until 2004.
And what was your rank?
My rank at retirement was captain, the equivalent to a full colonel in the other services.
And I believe you indicated you're out of the reserves currently, correct?
Yes, I am. I'm retired.
Now, one of the positions you held also include being a non-attorney advocate for children.
That was not a paid position. That was something that my husband discovered could be done for students who are going through the discipline process. I don't consider it a position because we never got a penny out of it. We spent our money and we helped people get their kids out of a really tough place. It was a volunteer activity that we took on.
You say we took on. Who
My husband and I.
And who was he?
John W. McLaurin.
Could you spell his last name, please?
Capital M, lowercase c, capital L, A-U-R-I-N.
And so you and your husband have served as non-attorney advocates for children, is that correct?
Objection vague as to when.
Very good. I just want to know as to whether you did that, and then I'll ask a follow-up question.
I think children is probably misleading. The people that we helped were in high school. They're high school students.
But what time frame did you help these high school students?
I don't know when it started. I know that before I was even ran for school board, we had stopped doing it because it was so expensive.
Were you an advocate for, non-attorney advocate for children in 2007?
I'm not sure.
2008?
No, I don't think so. 2008 is the year I ran for school board. I can't say for sure about the beginning of the year.
Of which year?
Of that year you mentioned, 2008.
Okay.
I just don't know. I just don't know when we started and when we stopped.
How long did you do it?
It seemed like forever when we were doing it. I guess, I have to guess, a couple of years.
So you served as a non-attorney advocate for children for approximately 2 years, is that correct?
I'm not sure. I'm not sure how many years.
Can you give an estimate of how many years you were a non-attorney advocate for children?
As I said, I think the term children is way misleading. They were teenagers in high school that we helped. We did not help young children.
No, I was trying to use the term you used, I believe, but so you want to clarify that you were a non-attorney advocate for teenagers?
For students.
students.
because the problem was with the educational institution.
Could you explain what you mean by what you just said?
Well, how do I say it? These were young adults who were being accused of having committed some kind of unlawful behavior by the school district.
And you only represented teenagers, correct?
As it turned out, yes.
Has talking about it refreshed your recollection at all in terms of when you served as a non-advocate, a non-attorney advocate for students?
No, it hasn't. It has reminded me of the young people we were involved with.
Well, I'll show you a letter, and counsel, I'll give you a copy first.
Thank you.
Dated March 1, 2007. I believe we redact this, and I'm not sure if we'll make this an exhibit to the deposition. We've redacted this for purposes of keeping student confidentiality. You see the date at the top corner of the page which says March 1, 2007?
Yes.
And do you see the reference to, at the lower right-hand corner, to you as being a non-advocate attorney, and then the student's name is blocked out?
Yes, non-attorney advisors.
Non-attorney advisors, correct.
Yes.
This was written by a parent in a case concerning a student that you were working with as a non-attorney advisor, correct?
Mm-hmm. I don't know. I haven't seen this letter before.
Okay, why don't you take a look at it? Have you finished reviewing the document, ma'am?
Yes, I have.
Does that refresh your recollection that you served as a non-attorney advisor for students, at least as of 2007?
No, it doesn't. This letter is dated March 1st of 2007. She requested copies in February 20th of 2007.
I'm going to object as she's being non-responsive. She's already answered the question.
I can't tell if the activity was before 2007.
No, I didn't ask if it was before 2007. Does this letter that I've given to you, and we haven't marked it as an exhibit yet, which is dated March 1, 2007, received March 2, 2007 by Administrative Services, which I'll represent to you would have been Administrative Services for Jurupa Unified School District. Does the reference to you as Captain Noreen Considine in the text of this letter, dated March 1, 2007, refresh your recollection as to whether you were a non-attorney advisor as of approximately 3 years ago?
No, it does not.
I will ask then that a copy of the letter be marked for reference, if we need to, as Exhibit 1, if we need to reference this document again. Now, what training did you have to serve as a non-attorney advocate for children?
Advisor, I believe is the word. Non-attorney advisor.
Okay, a non-attorney advisor. What training did you have?
I'm going to object to this question as it has no connection with the facts or the circumstances of this case.
Okay.
But you can answer.
Okay.
I don't remember where it is written that a student has the right to have someone other than their parent or a lawyer. And if it's not a parent, it's not a lawyer, apparently they're called non-attorney advisors or non-attorney. I don't think they use the word advocate. That's a different term. And I think that anybody can do it.
And I asked, what training did you take?
Well, there's nothing required.
I didn't ask if anything was required. I was asking if you did any self-teaching, took any classes. Did you do anything to train yourself to become a non-attorney advisor for students?
My husband went to law school for 1 year. I did not. I was his sidekick.
Well, aside from your husband going to law school for 1 year, by the way, what law school did your husband attend?
I don't remember what it's called now. It's here in Riverside.
Aside from your husband taking 1 year of law school, did you do anything to train yourself to serve as a non-attorney advisor for students?
No.
Well, have you ever studied the education code?
I've read the education code. I don't know what you mean by studied.
Have you read the entire education code or a portion of the education?
Portions.
Which portion of the education code have you read?
I can't possibly pull that out of my head without having the ed code in front of me. I don't know.
Have you read the California Penal Code?
Some of it.
Which portions?
I couldn't say.
Do you recall which portions of the education code or which issues, the portions of the California Education Code you've read in the past?
No.
Concern?
No, I can't.
Do you recall what issues, the portions of the California Penal Code you've read concern?
No.
I'm sorry, I'm just making a note. Okay, so you've served as a trustee of the Jurupa Unified School Board since December of 2008, is that correct?
That's correct.
Since being elected actually, were you elected in November of 2008?
Yes, I was.
Since being elected in November of 2008, have you taken any courses or engaged in any self-training to educate yourself about the rights of students or anything pertaining to the administration or operation of school districts?
I went to a conference that had several such classes.
Which conference?
It's given by the California School Board Association.
When?
It was in, I believe it was in December of 2008, thereabouts.
What classes did you go to in December of 2008, the California School Boards Association?
I remember sexual harassment training, awareness training, and I can't remember the others.
So aside from the sexual harassment awareness training which you took in December of 2008, you can't recall any other trainings you attended?
No, I can't.
Aside from the conference in December of 2008, which was operated by the California School Boards Association, have you attended any other classes or seminars of any sort concerning the operation of school districts or student discipline rights?
Yes, I have. Something given by the, or given in the city of Riverside, but I can't recall what it was right off the top of my head.
Who sponsored the course in the city of Riverside?
I can't say. I don't know if this.
When was it?
I don't know. I'd have to guess. I'd be guessing. I've been on the school board since December of 2008 till now, somewhere in that period.
Who taught it?
I think it was somebody from the DA's office, because I remember the district attorney being there.
Who was the district attorney at that time?
Ron Pacheco.
But you don't recall the subject matter of the course?
Not as I sit here, no.
Did it pertain to student rights?
Student rights, I don't know.
Now, why did you decide to become a non-attorney advisor for students?
I'm going to object on the grounds that this has nothing to do with this case and not likely to produce any admissible information or discovery.
You can answer the question.
Somebody had to do something for a young man that his mother was very unhappy about what was being done to him. And so my husband got involved, and then I got involved.
What do you mean something had to be done? Explain that, please.
This boy was, he had a bottle of water, the larger size. This is larger than this. It's about a liter, I guess. And the ninth grade science teacher had given them, had showed the students the process of sublimation with using dry ice. When the class was over, she threw, like so, he said, this young man said, and kids all had, some of them had pieces of dry ice. One of them put it in a bottle like this and put the lid back on. And it was starting to bulge, so this young man picked it up, and people passed it around, and to make a long story short, he was the one who had it in his possession when it popped. It made a loud noise. It sounded like, in the way he described it, is nobody in the school knew what to do. They were all running around in circles. Somebody called the police. They took him away and put him in juvenile hall for a couple of days. And he had a hearing in which he was found to have made a bomb and set it off in school. And
He had a hearing where?
pardon me?
He had a hearing where?
Oh, they had a hearing in the district. This is one of the. They have hearings whenever they have a kid who they want or should be, or somebody thinks should be expelled or suspended or brought back or whatever. And
So what kind of hearing was the young man subject to?
the hearings that they have here on student discipline.
And when did this occur? This
Oh,
incident
gosh.
with the student with the dry ice on the bottle that you just described?
It was the first time that we had anything to do with the district. It was the first time for everything, as far as we were concerned. Hearing the details that we did, we know that there was no bomb and it was not set off in school. This kid did not mean to be locked up in jail for 3 days.
My question was, when did this occur?
I don't know. I can't say. It was a few years ago. It was the first one we did. I don't have a reference that I could say it was 03, 04, 05, 06. I don't know.
When you say 03, 05, 04, 06, you're talking about year 2003, 2004, 2005?
Yes. It was a couple of years ago, but I can't say how many because I just don't remember the date. There's nothing that I can cue into it that would tell me what year it was. I don't know. I don't have any records in front of me. I don't know. I don't recall.
Does referring to Exhibit 1 to the deposition help refresh your recollection?
You mean that letter I read?
Yes.
No. Was that about this case? It doesn't seem. I can't tell from that what case it was about. It seems awfully late. 07.
Well, the name was redacted off of Exhibit 1 to preserve the confidentiality of the student's identity.
I understand, but I don't get anything out of that at all. It's not familiar.
Well, let me ask you this then.
What?
Have you been a non-attorney advisor for multiple children or multiple students?
What do you mean by multiple?
More than one?
Well, yes. Are you talking about a group of people or several individuals?
I'll ask the question as to both.
Well, there were, in this case, there were other kids that got punished because they were around this boy when this thing popped. And they got punished because they laughed.
Did you represent them?
No, and they turned out not to need representation because when we were able to show that there was no crime, there was no bad actor. No, there was a bottle of water and some dry ice. The case against the other kids were dropped. I think there were 2 or 3 other boys.
Well, did you represent those children?
No, there was no hearing.
So you only represented, as a non-attorney advisor, the young man who was subject to, and what was the form of discipline he was subject to?
The form of discipline was to be expelled.
Okay, did you represent him?
No, because we didn't know. All this stuff happened before we knew. We were working at getting his record cleared off, whatever you call it, and we were able to do everything except the sheriff. The sheriff would not expunge his record.
So the young man you represented actually was charged with a crime?
Yes. Well, yes. I guess he was if they put him in jail. I don't know. I don't know what the process is. I can't say what being charged with a crime means.
Do you understand what being charged with a crime means?
I don't understand the terminology, whether that means he had a hearing or whether they just took him and put him in behind bars for a couple of days.
Do you know whether or not he was charged with a crime or not?
I don't know.
Yes or no?
I don't know.
Okay.
I said what I did know.
Okay.
And you said the expulsion of the young man that you represented was actually stopped, is that right?
Yes.
But have you represented other students aside from the young man who was involved with the incident with the water bottle and the dry ice?
There was one other case.
When was
A couple
that?
years later. It was a couple of years after Ziad's case, so I'm not sure.
After what case?
Ziad. This boy.
Was that a name?
Yeah.
Okay, yeah, don't use the students' names.
Okay.
Those are confidential, so.
I understand that, but we also understand that everybody in the school district knows about it and they know who it is.
Okay, just answer this
Okay.
question.
There was one other case that we took on
When was that case?
a couple of years after the dry ice case.
Okay, and you represented another student who was involved in what incident and what capacity did you serve in?
Well, we served as non-attorney advisors to this high school student who was accused of picking girls up and carrying them around.
And was he also subject to expulsion?
I am not sure.
And I take it
No.
the high school student was a male. Is that correct?
Yes.
And you're not sure if he was subject to expulsion?
I can't remember that detail.
Well, in what capacity were you involved?
In helping to show that he did nothing wrong and that he should not be expelled or suspended or whatever the heck it was.
Now, when you say he did nothing wrong, do you mean he did not do the act of picking up girls and carrying them, or that he did nothing wrong at all?
He did not do, they could not show us any evidence at all that he did what they said he did.
Didn't they have statements by the girls who claimed that he had picked them up?
They had unsigned statements of unknown people saying that he had done this, and they would not tell us who they were.
Well, do you understand that in some situations, school districts are hesitant to tell even non-attorney advisors of who witnesses might be for fear that there might be action against those witnesses?
I'm going to object as calling for speculation and
Yeah,
lacking
I'm-
foundation, and I'm going to instruct her not to answer.
Yeah, this is,
Just,
okay. It's just, could I say one thing? No, I won't.
All right, then let's explain, since your attorney's instructed not to answer that question, let me ask you this question. What do you mean that, first of all, when you say they couldn't prove, who are you referring to?
They couldn't prove.
Who is the they? Who are you referring to as they when you say they couldn't prove to you that he did what they claim he did?
The district.
The school district.
That's correct.
Okay. What do you mean when you say, in this incident about 2 years ago, with a young man who allegedly picked girls up and carried them around, what do you mean the school district could not prove that he actually did it?
The school district refused to identify who the girls were, or when this events supposedly happened. Not only they wouldn't tell us, they wouldn't tell the boy or his parents that he was being expelled for, I guess it was expelled for doing something that they wouldn't tell him what it was.
But they told him he was accused of picking girls up and carrying them around, right?
At some place, and nobody knows what girls or how many girls, or who they were.
And you believe a school district should give that sort of information to people from the community, such as non-attorney advisors?
I'm going to object as irrelevant. But you can
No, that's not what I said. You're misconstruing my point.
Correct.
They wouldn't tell the boy who supposedly did this, who was complaining against him because it made them uncomfortable.
Do you believe that there's some requirement under the law?
Yes. I do.
Where?
Where?
Yeah.
I'm not a lawyer. I don't know.
What do you base your belief upon?
My husband is the whiz in that area. I am not.
But I'm asking you.
Well, I don't know. I said that already. I don't know the law.
Well, let me just be clear then. You say you don't know the law, but you have a belief that the boy should have been told, the boy in the incident you just described, supposedly picking up girls and carrying them around, that he should have been told what girls made that accusation against him, correct? That's your belief, correct?
I
I'm
do.
going to object.
Yeah.
It's been asked and
I'm
answered.
I'm
Just
not a lawyer.
Stop.
You're trying to push me into some corner. Okay.
I'm going to instruct her not to. She's asked. You've asked her. She's answered. Please move on.
Very well, counsel. I'm not agreeing with your objection.
I
I'm
understand.
just moving on.
Sure.
Okay, would you please explain your duties as a trustee of the board of Jurupa Unified School District?
Well, we are, the 5 people that are on the board are responsible for seeing that the school district is run properly.
Anything else?
Anything else? I would say that covers just about everything.
Does the Board of Trustees for Jurupa Unified School District also participate in any way in the student discipline process?
Yes.
In what way, ma'am?
They are the, someone put it this way, the court of last resort.
Who put it that way?
Somebody, I can't say who, somebody who was telling us, or maybe telling me, what our role is when student cases come before us to decide what their fate will be.
Do you remember who that person was?
No.
Okay.
Do you recall when you were told that?
No. Early on.
Early on? In what
Early
part?
on, my time as a member of the governing board.
So that would have been sometime after December of 2008, correct?
Yes, I think so.
Do you actually vote as a trustee on student discipline matters?
Yes.
Would you explain that process, please?
I'm going to object as it's vague and it also could infringe on the deliberative process. Could you maybe hone that a little bit?
Yeah, I'm not talking about a particular issue or a particular student. I'd like you to explain to me your role in voting on student disciplinary matters as it relates to your overall responsibilities as a school board.
We are given documents on each student who's to be considered and decide from that whether to implement the recommended. It's not always punishment. Sometimes it's recommended they be restored to school. So recommendations made by the administration, whether we agree with them or disagree with them.
Do you do anything else
Objection vague as to...
as in your role as a trustee?
Well, yes, everything comes past. Well, not everything comes past us. Budgets and policies and so forth come before us to review before they're implemented.
Do you do anything else in your role as a trustee?
Yes, but I can't think of them right now.
During the time you've been a trustee on the Jurupa Unified School District, have you contacted any students or parents as a potential non-attorney advisor?
No. No, we haven't.
Now, in either December of 2008 or January of 2009, isn't it true that you actually received information from the district administration, including Elliot Duchamp, as to the overall student disciplinary process?
I don't understand the question.
Did you ever attend a meeting with any of the district personnel in December of 2008 into January of 2009 where you went over the student discipline process?
I probably, there were, yeah, it was a module of training, I believe.
And that would have been in December of 2008 or January 2009, correct?
I can't say exactly when.
It was shortly after you were elected, correct?
I don't know.
Who was there?
I don't know.
What were you taught?
On the disciplinary process,
Yes.
I couldn't say from here without reviewing. I have to guess that it was a step-by-step through the disciplinary process and what it meant. But I can't honestly say that's exactly what it was because it's been a long time. And I haven't studied for this. I haven't reviewed it for this case, this what we're doing.
You mean what we're doing here in the deposition?
Yes, yes, I don't have it at, at my fingertips at on the edge of my tongue.
Well, you tried to initiate a class action lawsuit against the school district, didn't you?
No.
Okay. You tried to initiate a federal district court case against the school district, didn't you?
Yes,
That was in last year, correct?
that was last year. It was yeah, same day that your firm filed against me for something or other.
Well, I'm going to show you, I'd like to have marked as Exhibit 2. Counsel, here's a copy for you.
Thank you.
We've handed you a document which we've marked as Exhibit 2,
Yes.
which is a pleading, which shows at the top of the page
Which is, what did you say? This is,
It's a
I
pleading.
missed the word. A
He said
pleading.
pleading.
Okay.
a pleading,
Uh-huh.
which for purposes of identification has at the upper left-hand corner the name Richard D. Ackerman,
Yes.
Ackerman, with the caption entitled United States District Court in and for the Central District of California, case number EDCB 09
Yes.
-00455 VAP. You were the plaintiff in this lawsuit, correct?
Yes, I was.
And Mr. Ackerman formally represented you, correct?
He did.
Does Mr. Ackerman still represent you
No.
in any capacity?
No. Not to my knowledge.
What do you mean, not to your knowledge?
I'm going to object on the grounds that this is irrelevant and it's not likely to produce any admissible discovery at trial. It's privileged.
Since you claim privilege, I take it you're going to instruct him not to answer that.
Yes.
Very well.
Actually, could I confer with my client aside for a minute and maybe let me talk to her and maybe I could get her to answer that question?
Of course, counsel. We'll take a break off.
Going off the record, the time is 1:32 p.m.
Mr. Clark, I believe you had a
Hold on one
question.
sec.
We are back on the record. The time is 1:38 p.m.
Mr. Clark, I believe you had a question as to whether or not Mr. Ackerman currently represents Ms. Considine.
He does not.
Very well. Now, you said that the federal district court case that you filed against Jurupa Unified School District last year was not a class action. Is that correct?
That is correct.
So you understood the nature of the lawsuit you were filing against the district on which you serve as on which the board you sit on is the Board of Trustees, correct?
Yes.
Would you turn to page 4 of the federal district court case,
Okay.
federal district court complaint? Are you there?
Yes, I am.
And you see paragraph 10?
Mm-hmm.
Do you see that?
Yes, I do.
I'm going to read a portion of it for the record, and then I'm going to ask you a question about it. And by the way, you read this entire complaint before it was filed in federal district court, correct?
Mm-hmm.
Is that yes?
Yes, it is. Yes, I
and
did.
you believe that the allegations in the federal district court case are true, correct?
Yes, I do.
Okay. And then you say, quote, all students attending JUSD schools have a due process right to a fair, timely, and fact-based hearing with respect to suspension, expulsion, or other drastic forms of discipline affecting the student's records and reputation. Period. As of 2008 and continuing to this day, due process complaint hearings are not provided. On what do you base that assertion that you stated in this federal district court case complaint?
I'm going to object as it's irrelevant and it has nothing to do with the facts or circumstances of this case. But you can answer.
What part of that was your question?
On what do you base the assertion that due process complaint hearings are not being provided in Jurupa Unified School District?
My attorney at the time and my husband explained that to me. I'm not an attorney. I can't give you an eloquent response.
Well, you know what due process complaint hearings are, correct?
Yes,
You vote on those as a trustee, correct?
yes.
You've actually been to some in the district, haven't you?
Been to somewhat.
Expulsion
Hearings?
hearings, yes.
Yes, I have.
So even before this lawsuit, you knew that expulsion hearings were occurring in the district, correct?
Yes,
So when you're referring to due process complaint hearings, you're referring to expulsion hearings, correct?
yes.
And you know that expulsion hearings, as of 2008 to today, still go on in the district, correct?
Yes, they do.
So why did you say they're not being provided?
Objection. Relevance has nothing to do with the facts or circumstances of this case.
You can answer the question.
I believe they are not, they're not conducted. The students don't have due process.
Explain what your understanding of due process is.
I'd rather explain what happens that I believe is not the due process. They are not given a fair hearing.
I know you might rather do that, but I'd like you to answer my question first.
Well, in due process, I would expect that they would, that all the facts would be brought out, that the student would know who is blaming them for something, what it is. I don't know how to put that in more lawyerly terms. If somebody accuses me of something, I'd like to know what they're accusing me of, and I'd like to know who's doing it. I don't think that's too much to ask. They would have, as their panel, people who are impartial. They would not accept affidavits that are improperly done. They would not have, see, this is a backward way of doing it. They would not have something that they signed revised by a student, excuse me, a teacher or a guidance counselor so that it said something different, and then typed up in that manner and given to the board as something that he admitted to that he did not. Wouldn't that be a fair process? Is that going in the right direction of a fair process?
I can't answer questions here, ma'am.
Well, I know you can't. I'm the one that answers the questions. I think all that, what I have seen and what people have told me as they have participated in have been very disappointing.
Well, are you familiar with the legal standard in terms of how expulsion hearings are to be provided under the law?
I've read it. I've read it, and it's what we have, and what we do is different.
How?
Well, where shall I start? Where shall I start?
Tell me how.
Okay, well, I'll tell you what I see. What I see as a board member, I I see nothing of the student's side of the story. We have affidavits by people who, actually they're not the actual affidavits, it's a C original for signature. So there's no signatures on the affidavits that we get, if we get any. We don't, the evidence we get is a photograph of something that said, this is the, whatever it is, tool, this is the gun or the tool that he used. We have nobody there on the, nobody tells us what the kid's side of the story, the board. We get a nice little compact story of what we're to believe happened.
Do you know whether parents have the right to request the opportunity to address the Board of Education?
They do. We had one once.
Do you know whether parents, on behalf of their children, whether they be young children or teenagers, have a right to appeal a decision of the Jurupa Unified School District?
Well, I know that. I don't know if they know that.
Well, have you asked anyone from Jurupa Unified School District if parents are advised of their rights, for example, to appeal or to appear before the actual school district board?
I don't recall if I asked that question or if someone voluntarily told me.
But when you filed this lawsuit claiming a lack of due process in 2009, you actually knew, didn't you, that Jurupa Unified School District provides a list of rights to parents, right?
I don't know about that list. What did you say?
I'm sorry?
I said I don't know what list you're speaking of.
Do you know if Jurupa Unified School District sends notices to parents of children, or to use your term, teenagers, up for expulsion as to what their rights are?
I do not know whether parents get such thing. I don't know.
Have you ever asked anybody?
Have I ever asked anybody? I don't know.
Haven't you seen it when you were serving as a non-attorney advisor? When I say it, I'm referring to the list of rights that students have in expulsions.
I don't recall.
Are you familiar with the fact that expulsions may be appealed to the Riverside County Board of Education?
I am, yes.
And what steps did you take to, when you became a trustee, to make sure that that information was provided to parents?
I don't recall anything.
You didn't do anything, did you?
No, I didn't. No, I didn't. I did not take the lead on that.
So why didn't you at least try to make sure your school district was advising parents and students of their rights during expulsion instead of filing a federal district court case?
Well before I did this, which was the last straw, the last opportunity, I asked the superintendent about how these discipline hearings were handled, and he said that it didn't matter much in the kid's life. It goes away when they graduate from high school. It doesn't follow them, so it didn't matter much.
When you said the superintendent, you're referring to Elliot Duchamp?
Yes.
When did you have that discussion with him?
You know, I can't tell you the time. While I was on the board.
Okay.
Rather early.
Okay, then let me ask you this. As a trustee of the Jurupa Unified School District Board, you know you can place things on the agenda, correct? Mm-hmm. Is that yes?
Yes.
Did you ever place on the agenda as a discussion item for public discussion whether parents and children who are up for possible expulsion get sufficient notice of their due process rights?
Yes.
You did. When?
I can't tell you when. I can't tell you exactly when. I remember the meeting, and I remember my saying that due process right that they're not getting.
No, that wasn't what I was asking. When did you, as a trustee of Jurupa Unified School District, ask to have as a subject for public discussion, and perhaps even staff report, as to how students' due process rights were being provided, indeed whether they were being provided to parents and children or young people, students up for expulsion?
I put something on the agenda, similar to what you're saying.
When?
Well, I don't know. One of the meetings a long time ago.
When? Along, what would have been in the past 2 years, right?
Yes, it was early in my time on the board. It was certainly not the first meeting, and it's not been recent. It's been quite about 2. I don't know how long it was. If you're trying to get me to say it was a certain date, I don't know what date it was.
Okay. What happened during that? Was it discussed during public session? And when I say when I'm referring to it, I'm referring to, was it the issue of how parents and students who are up for expulsion get their due process rights? Was that discussed?
I brought it up. I discussed it. Nobody else chimed in. Nobody asked. There were no questions. There were no comments.
Well, in that meeting you had with district staff, and was legal counsel there in December or January of January 2008, January 2009? At that meeting you had where you discussed student discipline issues, did you raise the issue then?
You mean the first or second meeting I attended as a member of the board?
No. Do you remember telling me that you attended a meeting with district staff to go through the student discipline processes?
Yes.
That was at the district office, correct?
Yes, it was me and Mr. Duchamp and a third person. It was either an attorney from this firm or it was somebody from the administration.
And did you ask what documents actually go out with an expulsion packet that advise students and parents of their due process rights?
I don't remember anything that specific.
Why, have you ever asked to see the packet of information that goes to students and parents concerning their expulsions?
Objection, asked and answered. Don't answer that.
I did answer that. I said I didn't know.
Okay.
I don't remember.
All right.
So when you're giving me this list of items that you think are part of due process, that all the facts brought out, that students should know who accused them, that there should be impartial people on the panel, that affidavits that are not properly done should not be accepted.
Excuse me, where are you in this document?
I'm referring to my notes as to what you told me just about 5 minutes ago.
Okay.
Okay, let me make sure I understood you correctly.
Okay.
It's your belief that all the facts should be brought out concerning the student's expulsion, correct?
Yes.
And do you believe that's happening at Jurupa Unified School District?
No.
Why?
I don't know why. I know from what I've seen and what I have heard that it's not true.
Why do you say that?
Experience. My experience and my talking to kids who have been hurt by the process.
Who have been hurt by, what do you mean by hurt by the process?
They kicked out of school. They missed their graduation because they are not allowed back in the school until after graduation.
Well, you understand that part of the responsibility of Jurupa Unified School District is to keep safe schools, correct?
Yes.
And do you understand that the responsibility of Jurupa Unified School District to keep safe schools has to be balanced against a particular student's desire to attend a school even if they did something wrong?
It would depend on what the something wrong was. And if it's his own graduation and all that he owes the school is $500 for some damage to something, I don't think the person that owes $500 should be not allowed to graduate.
Okay, let me be clear about what you just said. You're aware of a student who was subject to expulsion because he did some property damage at the school, correct?
That's what was alleged.
And he did $500 worth of damage, correct?
That's what was alleged.
And part of his conditions to being let back into school was to repay the $500, correct?
That's what was alleged.
And he didn't repay the $500, correct?
That was what was alleged.
Did you talk to the student?
No.
So you don't know whether he tried to repay the $500?
I could not find the student, and I'm not sure that I'm allowed to talk to them.
I thought you just said from talking to students, you believed that the...
Not talking to the student that's been kicked out, but talking to other kids. This kid, I couldn't find.
So you're aware of a student who district staff informed you, as a condition to returning to school, needed to repay $500 for damage to school property, correct?
That was the student discipline record.
And you believe that even though the student did not repay the $500, he should be allowed to attend graduation, correct?
I think he should be allowed to attend anything he wants to attend.
Whether or not he paid for $500 of damage of school property or not, correct?
Are you talking about graduating, or you're talking about sitting in the audience?
Is the answer to my question yes or no?
I didn't understand the question.
Okay, when you said he couldn't attend graduation, what did you mean?
Well, he did not graduate with his class. But I also know that these kids are not, because of other people that I've known, kids, that they're not allowed on the school property until their time is over. They're allowed back into the system.
All right. Were you finished with your answer?
Yeah?
Okay, let me ask you this then. Is it your position that even if a student causes $500 of damage to Jurupa Unified School District property, he should be allowed back onto campus?
Yes.
Why?
Because this country supposedly is a free country. You can come and go as you want unless you are in jail.
One of your concerns about due process of Jurupa Unified School District was, and tell me if I'm incorrect here, that the students do not know who their accusers are. Is that correct?
Well, that was the case, the second case I had. I don't know of how many others there were because it's been, I just know this one case. This kid was not allowed to know who was accusing him of doing something at a time and a place that was unclear.
During the period from December of 2008 to today, as we sit here in August of 2010,
Yes.
about how many expulsion cases have you seen come before the Board of Trustees of Jurupa Unified School District?
Let's see. Maybe 200.
So out of the 200 cases that you've seen come before you, you're aware of only one case where a student did not know who his accuser was. Is that right?
Well, that was because they came and found us, wanted us to help them.
My question was, of the 200 cases that you've been aware of as a trustee on the Jurupa Unified School District Board, you're aware of one case where a student, according to you, did not know who his accuser was, correct?
That's not a yes/no question because the way you've posed it is not factually accurate.
Are you aware of other cases other than the one you just discussed where you felt that the student wasn't entitled to know who his accuser was?
Actually, that wasn't my question. My question was, I appreciate you trying to clarify, counsel. My question is, do you know of any other case other than the one that you referred to earlier concerning the sexual harassment, alleged sexual harassment?
Sexual harassment?
Yes. Would you, well, let me ask you this. If a male student was picking up young women and carrying them around do you believe that might expose the school district to a claim of sexual harassment if that...
I'm going to object. It's irrelevant. It's not likely to produce admissible evidence. It has nothing to do with this case. I've let you go on down this path quite a while. I'm going to instruct you not to answer that. It's irrelevant what your state of mind is.
So you're going to instruct him not to answer?
Yes, I am.
Very well. I'll move on. Again, not agreeing with your position, counsel. Do you know of any student of the 200 cases that you've reviewed as a trustee since December of 2008 who did not know who his accuser was?
I don't know the answer to that.
Why?
Because I don't know enough detail about the cases.
Then why did you make the assertion that you believe that students do not know who their accusers are?
I knew in one case for sure. Does it say here how many?
No, I was referring to what you told me here in the deposition.
I said students, plural. Did I? If I said students, plural, perhaps I should have said I know one for sure. Maybe there are others. I don't know.
You stated earlier, and correct me if I'm wrong,
Yes.
that the students who are up for expulsion in Jurupa Unified School District do not have impartial expulsion panels. Is that your belief?
Oh, yes.
What is your belief based upon, ma'am?
My experience with the panels.
You had 2 cases as a
Yes.
non-attorney advisor?
Mm-hmm.
Is that yes?
Yes.
So your belief that the panels are impartial are based upon your 2 personal experiences as a non-attorney advisor, correct?
I believe you said it 180 degrees. My limited experience is the people on 2 panels were not impartial.
And so your belief based upon your personal experience as a non-attorney advisor is that all of the panels, the expulsion panels at Jurupa Unified School District have people who are biased, correct?
I wouldn't say 100% no.
What percentage would you say?
I wouldn't know.
So when you said that you did not believe due process was being provided because the panels are not composed of impartial people, it's based upon your experience in 2 hearings, correct?
2 out of 2, yes.
Now you said, and correct me if I'm wrong,
Sure.
that the school district should not accept affidavits that are improperly done. Did I get that correct?
Yes. A court wouldn't. Why would we?
Explain that. Explain what you just said.
If an affidavit is not, my understanding of what the court will accept is if the affidavit has defects, it will not be accepted.
So you believe that the standards for an affidavit or declaration signed under penalty of perjury applies to statements by students in expulsion hearings. Is that right?
I didn't understand that at all.
Do you believe that the standards for civil or criminal court proceedings should apply to student discipline issues?
What do you mean by standards?
The standards of evidence, ma'am.
I believe that an affidavit is going to affect somebody's life, his future, his education. He should have access to the original with an original signature on it.
What is the basis of that belief?
Pardon me?
What is the basis of that belief, ma'am?
I don't want to see kids jerked around for something they didn't do.
What is the basis of your belief, ma'am?
It's the stuff that I've seen, the affidavits that I've seen.
What is the basis of your belief that the affidavits you have seen are not sufficient for student disciplinary processes?
They're not signed.
What-
They're not, wait a minute, yes, I can list two things. And they do not indicate in what jurisdiction they were signed. Well, they're not signed. We're not giving them signed. We're given something that's been typed from what the affidavit was.
What is your belief that there has to be a signature and jurisdiction on a student's statement as to what happened in a situation which might result in a student's discipline?
Well, that would tell you what jurisdiction, if the person had committed perjury, what jurisdiction it should be in.
What is your belief that putting down the jurisdiction is a requirement, ma'am? What is the basis of that belief?
I've read it somewhere in the law, I can't tell you where, that the jurisdiction has to be in there. The jurisdiction where it was signed.
Well, did you ask either the district staff or anybody connected with the district, including legal counsel, as to whether the requirements that you believe should be in student affidavits are required by law pertaining to student discipline?
I don't recall.
Okay. So as you sit here today, you don't recall what you read in the law. And let me just ask you this, was it the education code you read?
It's more likely penal code.
So you believe the standards of the penal code should apply to student disciplinary matters, correct?
I don't know. I'm not versed in the law.
I'd like to have marked as Exhibit 3 a copy of Ms. Considine's answer to the complaint in this matter.
Counsel, can you have her raise her mic up a little bit? She keeps hitting it.
Yes, of course.
I'm sorry?
Can you raise your mic up a little bit?
Mr. Barr, here's a copy of the answer for you.
Okay. Thank you. Thank you.
Is it Barrick or Barrick? I'm sorry.
Barrick.
Barrick. I apologize, counsel.
I've been called worse. That's all right.
I get called Clarky now and then.
Oh, dear.
Is this the answer that you filed in this case, ma'am?
It appears to be, yes.
And if you'll turn with me to page, let's see, 5 of the complaint. Oh, excuse me, the answer. And for purposes of identifying Exhibit 3, when I said, is this the answer, this is actually the formal answer that you authorized legal counsel to file on your behalf in this case, correct? This
Yes.
state court case.
Yes.
All right. And you read the answer before it was filed, correct?
Yes.
You understood it, correct?
Yeah, I think I did.
And do you see, under the 13th affirmative defense, a claimed affirmative defense of violation of law?
I'm sorry, say that again.
Do you see as a 13th separate and affirmative defense to the complaint, defendant alleges, paren, violation of law, close paren? It's at paragraph 14.
Yes.
And would you please read paragraph 14 to yourself and then let me know when you've read it?
Okay, I'm finished.
Now, you see that you're alleging, or you've alleged, that Jurupa Unified School District has violated California Penal Code sections 118, 125, 132, 134, 135, 136, and 182, correct?
Yes.
So you believe that the provisions of the Penal Code apply to student disciplinary matters, correct?
Objection asked and answered.
You can answer.
Yes, I do.
What is the basis of that belief?
A lot of what I've read refers to Ed Code, it refers to Penal Code. This is something that I read over a year ago. I can't be specific. I can't tell you what any of these codes are.
But it's your belief that the provisions of law that apply to criminal trials also apply to student disciplinary proceedings such as expulsion, correct?
Objection asked and answered numerous times.
Answer the question if you can, and I'll move on.
In some cases, yes.
What is the basis of that belief? Is it from a person, a book, or something else?
Objection relevance.
It goes to the good faith nature as to whether this is a proper affirmative defense counsel.
I'm sorry, I didn't understand.
I was responding to your legal counsel. I was saying that my question goes to the good faith basis for you asserting this 13th affirmative defense in this litigation.
I'm going to object on the grounds that it has nothing to do with the facts or circumstances of this case. Irrelevant. May infringe on the attorney-client privilege, and I'm going to instruct you not to answer.
Very well. I'll ask another question concerning paragraph 14 on page 5 of the answer, which is Exhibit 3 to this deposition. You say you see line 16, which refers to the Penal Code sections I just read? Do you see?
I'm sorry.
Do you see line 16 here?
Yes.
On page 5?
Yes, I do.
And you go to the end of the page, it says, including a multiplicity of offenses against students of the Jurupa Unified School District, as well as provisions of the California Education Code?
Yes.
When you say multiplicity of offenses, what are you referring to?
Objection, irrelevant, infringes on the attorney-client privilege, and instruct you not to answer.
Do you know what multiplicity of offenses are?
Same objection. Don't answer.
Now, another concern that you had about the due process that's provided in Jurupa Unified School District, you said that students have documents which they sign typed by guidance counselors. Is that correct?
I know of one case that is the fact.
So out of the 200 cases you've seen come before you as a trustee, between December of 2008 and as we sit here in August of 2010, you're aware of one case where a guidance counselor typed up a student statement?
And that is only because I had access.
Is the answer to my question yes?
It's no. I can't answer. I can't answer it because it's prejudicial. It assumes that I look at that I have a lot of information about everybody. I have almost no information about the stuff that comes across my desk. So I can't say that what's there is true or whether somebody typed up something that was not true over the kid's signature. I know in one case that it did happen.
When was
for
that?
sure. That was the one who was going to be expelled for picking up girls and carrying them around.
That would have been some number of years before you became a trustee?
Yeah, that was before I ran for office.
So you're concerned that due process in Jurupa Unified School District is insufficient is in part based upon something that happened before you became a trustee?
Yes, but that's not the whole story.
Okay, tell me what else.
Well, when I was a student advocate, I got to see all the documents that pertain, maybe not all, but I saw see a lot of documents that pertain to the student that was accused. And his response and his witnesses, what they said and did, and affidavits that teachers wrote up. And then listen to their, I'm not able to think of the word right now, testifying, listen to their testimony, and see for myself or hear for myself the difference between what they put in their I can't think of the word again. Their affidavits and their testimony conflicted. They did not say the same thing. Now, when we get them as, I want to switch now. I'm on the board now, a couple years later, and I see that what I see is a photograph, perhaps, of the thing that was damaged or the thing that was used, such as a gun or somebody scratching something into the floor. And allegations and a typed up summary of what somebody thinks happened. I don't see anything from anybody on the kid's side. I said this, I think, already a couple times. You're probably sick of hearing it. I am. There's nothing there that says, this is what I did. I'm a student, John Doe. I don't agree with what they said about me because. There's nothing from him. It's as if he's dead and gone and they're writing his epitaph.
Could it be, ma'am, that when the school officials interviewed the child, he admitted what he did?
Oh, they got him to admit the things, but...
What do you mean they got him to admit the things?
The guidance counselor says, go out and write down what you did wrong. And the kid goes out and writes up what he did wrong, and then she elaborates on that, types it up, goes into his record.
So you believe that if a student admits to what they did, it was because they were coerced or intimidated?
The ones that I know, yes.
How many do you know?
I know about 4 or 5 kids that happened to.
How do you know that?
From other kids. From other kids that they know.
So you know, it's your testimony that as a trustee, you know that children are being intimidated because it's not the perpetrator, but some of their friends who told other friends that a child was intimidated into admitting wrongdoing at a school. Is that right?
No.
Okay.
It's knowing the kid that got caught and him saying that he knows other kids the same thing happened to. I believe that we should get the whole story, not just what the people on the panel decided, but what did the kid do? What did he have to say about what he did? What do his witnesses say?
Okay, let me back up a minute for a second.
Okay.
Explain to me your understanding of the expulsion disciplinary process in Jurupa Unified School District as it's performed pursuant to Education Code, if you know.
As it is performed or as it is...
Pursuant to Education Code, yes.
Well, I'm going to object. That's a compound question, and it assumes that it's the district's disciplinary process conforms with the education code. I think that's my client's whole point. So
Okay.
maybe you could restate the question.
Do you believe the Jurupa Unified School District performs its expulsion process in a manner that's consistent with the education code?
No, and that's what the whole story has been.
Explain
For me.
why.
Explain why? And how many times have I said explain it?
Well, what have you seen that makes you believe that it doesn't comply with the code?
I have seen affidavits that don't hold up. Somebody, for instance, in one case, he said that, I'll go back to the so-called bomb, which some people still believe there was a bomb that went off when this kid had this bottle of ordinary water and carbon dioxide. The guidance counselor, I think he was, said, talked of a debris field 500 feet radius. But there actually was no debris field. There was a bottle like this. It split along the seam. It was in two pieces. And this man agreed, but he was not punished in any way. He was here until he retired last year.
Wasn't that case in 2002?
Oh, I couldn't tell you what year it was.
And that's the case you refer to in terms of the school district's expulsion procedures not being consistent with education code?
Well, that's not the only one.
Okay, tell me all the rest.
No, I don't remember everything I looked at.
How many were there? I'm referring to cases where the expulsion process was not completed consistent with the education code.
However many I looked at, that's what I thought, this is not right.
How many were there?
I'd have to guess.
More than one?
Well, yeah, more than one.
More than 5?
I've been on the board for a year and a half, however many I've seen.
Okay, estimate based upon your year and a half on the board.
How can I estimate? 20, 40, 60, I don't know.
All right. Let me step back from a particular case. Explain to me the expulsion process. Assuming a hypothetical child is accused of an expellable offense, what happens in sequence before it gets to the school board?
Well, there's a hearing panel convened.
What happens before the hearing panel is convened?
I do not know for sure because I haven't seen anything I haven't been a witness to anything that happens before the hearing panel.
I didn't ask if you were a witness. I was asked if you had knowledge as to the expulsion process before.
I'm going to object as argumentative counsel. She answered the question that she doesn't know.
She was explaining she had not been a witness.
And she said she didn't know.
Do you know from any other source other than being a witness as to what happens in an expulsion case before a student goes before an expulsion panel?
I am trying to think if I know something, if I can pull it out of my head at this moment. I know that the parents are offered that they can skip the whole thing if they just sign a stipulation that their child will not do whatever it was again.
Explain that.
I did. That's what it is.
Well, at what point in the process does that happen?
I don't know. I don't know where it happens. It happens before there's a panel convenes, because if there is no further action, in my understanding, if they sign the stipulation that the child will not do whatever it is he's accused of, then nothing else happens. So, until he does something wrong again, or until he's accused of doing something wrong again.
Aside from the stipulation you just described, explain to me the process. You started with a hearing panel is convened. Explain to me the expulsion process as best you know it.
The student is accused of something, and depending on what it is, he can be expelled right away. And then a panel is convened at some point in time, and he appears before that panel with his witnesses or people that will speak for his character.
So at the expulsion panel, and by the way, who makes up the expulsion panel?
The director for discipline apparently has a list of people that he rotates so that one person does not be on every panel.
Well, but who? I mean, are they school officials on the panel? Are they members of the community? Who makes up the expulsion panel?
My understanding, it is current and retired teachers and what's the other word for it? Guidance counselors and such.
What is the basis of that understanding?
I read it somewhere. And then I believe I read it. I believe this is what I was told when I was told what the discipline process was.
By whom?
I can't say. Somebody,
Was it your husband?
no, I'm talking about somebody in the school.
And as we're asking, as I'm asking these questions, I asked about your husband. Is your husband still a non-attorney student advisor?
No, after the last one, it was just too much money out of pocket and too much time. Then we just couldn't do it anymore.
So after the hearing panel's convened, what else next? What happens next in the expulsion process?
I don't understand what you mean by after this convened. Are you talking about what happens in the panel?
What happens after the panel?
Well, you just described. You said that before the panel, the student has the opportunity to present his side of the case and have people speak to his character, correct?
Yes. I also said he's offered, the parents are offered that they can stipulate that this won't happen again, and he gets his punishment, and there's no hearing panel. That's my understanding.
Well, it's possible that the hearing panel might not find there to be sufficient reason to expel the child, correct?
That's possible.
That happened in the case you were involved in, correct?
Objection vague as to what case she was
No,
involved
I don't
in?
like talking.
Didn't you say that the student who put the dry ice in the water bottle ended up not being expelled?
They voted to expel him. He was expelled before we ever knew about it.
Well, then was his expulsion suspended in some way?
It was suspended or vacated or whatever you want to call it after we talked to the superintendent and some other people in administration.
The school board actually overturned it, correct?
The school board did not hear from us.
I didn't ask if the school board heard from you. The school board overturned the panel's recommendation, didn't it?
I was not, if they did it in closed session, and I would not have known about it.
Well, does the school board hear expulsions in open sessions?
No.
So even during the time that you've been on the school board, expulsions are heard in closed session, right?
I don't know what you mean by heard.
Does the Jurupa Unified School District Board of Trustees consider student expulsion matters in closed session?
Yes.
And in the case that you described regarding the student who had the dry ice in the water bottle, the school board eventually decided not to expel him, correct?
He was already expelled.
Have you heard of the term suspended pending expulsion?
Suspended pending expulsion?
Yes.
No, I have not.
Is it your understanding that the panel that recommends expulsion actually expels the child?
No, they make their recommendation to the school board.
What body actually expels a child?
The school board.
So when you say that the student was already expelled when he went to the school board, what do you mean?
When my husband got involved and I went along with him, this boy was already expelled.
So we're talking about the boy, for purposes of clarity in the record, we're talking about the boy some number of years ago who had dry ice in a water bottle, correct?
Yes.
So when you and your husband got involved, the school board had already taken action to expel him, correct?
Yes.
So I thought you said you and your husband appeared before the hearing panel.
Oh, no, we never appeared. No. You misunderstood. We never appeared before a hearing panel. We went to a hearing panel as the persons who were speaking for the boy. We were not there as witnesses. We were there as...
I didn't say as
As his-
witnesses.
But appearing before them sounds to me like they're doing what? What is a? To me, appearing means being questioned by the hearing panel, and we were never heard by the hearing panel.
Okay, let me try and clarify my question.
Okay.
When you and your husband, I'm talking about the incident where there was a young man who had a water bottle with dry ice in it.
Yes.
Are we clear on that?
Yes.
You and your husband helped that young man present his case to the hearing panel, correct?
I don't think so.
Do you recall you and your husband being in a room with a group of people and the young man?
No, that had already happened before we knew about the case.
Okay. At what point in the process did you and your husband get involved?
He was already expelled, and we met his mother, and she told us what had happened, and my husband went to someone in administration, perhaps the superintendent, perhaps someone else. I don't know. I wasn't involved. Maybe Mr. Duchamp would recall, and said that this boy deserved another hearing.
Was Mr. Duchamp even the superintendent at that time?
I don't know. I said Mr. Duchamp, maybe him, maybe not. Before he was superintendent, he was assistant superintendent. I think he told me that he knew nothing about this case.
What did you and your husband, as non-attorney, let me ask the question this way.
Okay.
What did you and your husband, as non-attorney advisors, for the young man who had a water bottle with dry ice in it that caused some sort of explosion, do to help him overturn the expulsion?
I cannot recall. My husband did 99% of the work. I know that his expulsion was overturned or vacated or whatever you call it, and he was allowed to go back to his school.
And that's all you know?
Well, I know that he spent 3 nights in juvenile hall, and he has something on his record that the Riverside County Sheriff's Department will not change.
You understand that a school district has nothing to do with putting a child or keeping a child in juvenile hall, right?
Oh, yes. They called the police, and the police, or the Sheriff's Department did their thing.
Would it make sense to take a break?
Certainly.
Yes.
This marks the end of tape 1, volume 1. In the
Oh, I better
deposition
remember the
of
number.
Noreen Considine, we are going off the record. The time is 2:34 p.m.